Welcome to the Melanin Private Practice Group podcast with your host, Jaylyn. In this podcast, we focus on providing helpful information to new and existing mental health practitioners interested in starting a private practice and or those who are currently in it but just need a little bit of help. If you are ready to receive this word, let's dive in. Here we go.
Hello, hello. How are you? Oh, you're on mute. You're on mute.
I said, girl, it's been a day, but we can talk about that when we're not being recorded.
That is okay. Yes, I'm definitely down to have that conversation. So just a heads up, my camera is off. I'm gonna try to put a picture of it. Welcome everybody. If you're listening on the replay, you just gonna have to hear this part. You know, as entrepreneurs, sometimes time gets ahead of us, and my hair unfortunately got ahead of time. So I'm going to remain off camera for this little while, but I just want to thank you for joining us and sharing your expertise. As you know, we don't have any live active participants right now, but we're sure we're going to get some replays. We've already started to see that for Javante's video yesterday. So I'm excited for you, and I'm excited for what people are going to learn from you. So why don't we go ahead and start with your introductions, and then right after I'll say a little piece about me, and then we'll just dive into this conversation.
Sounds great. So thank you for having me. I'm excited to be on this journey with you. I'm Javante and everybody. I'm Naitasia Hensey. I'm an attorney. I'm based in Massachusetts, at specifically Boston area. I'm also federally licensed. I'm working on a couple of other jurisdictions right now. My primary bread and butter is contracts and contract law. I've been doing that for over a decade. I do contracts for businesses. I do them for nonprofits. I do them for individuals, all kinds of different subject matters. I also deal with trademarks for intellectual property and copyright rights regarding intellectual property, although I am not a litigator. And I also do other things related to business and entity formation and advisement.
I love it. I love it. You guys, I'm over here trying to contain myself because there's just so much I want to talk about with you tonight. And I know that this conversation is going to be good for a number of reasons. But before I let my excitement get the best of me, hello, everyone. I am Justin. I am the founder of JLW Medical Management Consulting here also in Boston, Massachusetts. I've been in practice now for 5 years, but operational for the last 2. And it has been a very rewarding experience. Just, how different business owners have developed their ideas over the years, and just being able to come in and help them take that idea, that vision to the next level. And so Naitasia and I linked up in Boston while Black. And I had mentioned to her that we have a coaching program that we were looking to launch, and we thought that it would be a great idea to talk about the legal side of private practice or group practice. And so a part of what we're going to do on this call today is just better understand how to prepare ourselves to risk-proof the practices so that we are compliant and we're constantly protecting ourselves. So my first question to you, Naitasia, is you started off by saying your bread and butter is contract. And so, what are the most important elements of any contract that practice owners should be aware of when they are not only hiring an attorney to do it for them, hint, hint, but also with making sure that if they do it themselves, they are protected, but we recommend an attorney.
Right. Okay. So the basics of any contract, any subject matter, you have to have an offer and acceptance between the parties, and then what we call consideration, which is an act or a service. So maybe it's a candle or widget, as we say in attorney language, as a product, or it's a service like you're providing therapy services, and then you need to bind that agreement. So that agreement needs to then be encased in writing. So that's the basic essential elements of any contract. There's way more that you need to include to protect yourself for a whole variety of reasons, but those three things will give you the basics of a contract.
I love that. And so, can you talk a little bit about what makes a contract not non-binding?
Mm-hmm. So, it could be non-binding if, for example, you don't include the parties, one of the parties in the contract. If it's a multiple party contract, for example, I see a lot of times that people forget to include somebody in their contract, and that person can't be bound to the contract because you can't bind somebody that you don't name. So that's a really common mistake that people make. A lot of something else that makes a contract non-binding is a lot of times people enter into verbal agreements, and then they will try to put that verbal agreement in writing, but they don't incorporate everything that they talked about verbally in writing, and they can no longer enforce what they talked about verbally once they've put it in writing. So not incorporating the entirety of what you're talking about and the entirety of the agreement between the parties is also a really big red flag and a big problem that I see when people try to negotiate their own contracts.
Wow, that's good. That's really good. And I can think of several instances where I've run across situations where something is discussed with one of our clients, and when they actually go to sign the contract, it's actually after they sign the contract that they realized that things were missing. And so my next question to you is, for especially for those who think that they cannot afford an attorney, what are some recommendations that they can look for to make sure that their contracts are meeting their needs as much as the other party?
Mm-hmm. So in the terms section or something like that, that would indicate the things that you agreed to for your contract. So let's say it's a medical-based contract and therapy or something, and you've agreed to 8 sessions at $100 an hour or something like that. Just throwing that out there. And that's what you verbally agreed to. But when you get down to the paperwork, you now see it says 7 sessions at $125 an hour, and you're in the terms, in like terms and conditions, right? We would say that, but in this services contract, it's just going to be terms. You will always want to pay attention to that. Are these the terms I agreed to? Is this something that we talked about? And if not, before you sign it, you want to go back to your other party and say, this is not what we agreed to. Once you sign it, there's not really anything that you can do about enforcing it, not enforcing it. I mean, you can take them to court, yes, but then you've got to spend the money and deal with that situation because now you've already signed an enforceable contract. So you want to do your due diligence before you sign it. Always pay attention to the terms section to make sure that the actual, or if there's an appendix possibly, because sometimes there's a lot of detail in what you've agreed to. And so there might be like an appendix A or something like that. You'll want to read that as well to make sure that it all is what you've agreed to.
That is really good. I love that you went there because yesterday on Javante's call, for those who are watching the replay, you might remember or recall the conversation that Javante and I had. Excuse me, everyone. I'm sorry, everyone. So I'm working in the co-working space today. All of the telephone booths are booked, so I kind of had to wing it. So I apologize for the interruptions as the voice does carry. But we will try to buffer it out as much as possible. So going back to what I was saying about yesterday's live, we had an amazing conversation with Javante Culbreth. For those who remember, we talked about everything bookkeeping, making sure you are on the money. And so today, well, in that conversation, there was mention about contracts and the importance of making sure that when providers are signing these contracts, that they are following them. They are making sure they pay on time and making sure that if they're unable to pay on time, that the terms reflect, you know, how do we say, flexibility. So my question for you is, what can providers do to protect themselves from legal liability when they are dealing with insurance companies that don't always pay on time and can cause delays where they upfront money and because they haven't been reimbursed, they are placed in a position where they could potentially delay payments and open themselves to liability. So what are some things that they should discuss with an attorney to protect themselves in that case? You're on mute. You're on mute.
I got it. This is a contract between the attorney, the provider and the insurance.
So it would be a contract between the provider and a contractor, provider and employee. Like, how do they make sure that they are protecting themselves when they have not been reimbursed in a timely manner, but they still owe the money?
Okay. So if possible, when you initially negotiate a contract, I would try to put in some kind of payment penalty if you are not paid on time or in a net 30 is often a condition on a lot of medical insurance and kind of those kind of contracts. They are 30 days from invoice kind of contracts, but then they don't meet their 30 days. So I would try to put something like that into my contracts if I could negotiate that up front. If I can't negotiate that on my contract between myself and my pay or the insurance agent, the insurance company, and it's between me and my client and that situation, I would not, for equitable reasons, because I try to be a very equitable attorney myself, I would not try to pass that fee or that detriment off to my clients. I don't think that that's right or fair. But I would probably put in some kind of agreement with my clients where if there is a delay in their insurance after a certain point, because I also put pressure on their insurance, that we may have to put delay in their service or something like that, which is also not awesome. But it's better. I think it's better than dinging them financially, because then it's just adding more piles onto the pile. Um, it's it puts, unfortunately, in my opinion, the healthcare system puts us in a very difficult position in how we handle this particular matter.
Oh, yes. Oh, yes. But you brought up something that a lot of people don't realize. Contract negotiations with insurance companies. A lot of therapists don't realize that they have the ability to negotiate their contract. So, is there a way to incorporate that in the contract with the insurance companies?
Yes. So in your payment terms section, they'll talk about what their um turnaround times are for payment. You'll see terms like net 30, payment due upon invoice, uh net 60, which is like, oh my God, who wants to wait 2 months for a payment? Or
Right.
like due payment, or payments are made on the 15th of the month if invoices are received on the 5th, kind of language. And so you want to pay attention to what that says. They're most likely not going to change that information, because that has a lot to do with what their payment system already is. That if their payment system doesn't allow them to pay an invoice for more than 30 days after the fact, then there's not much you can do about it. But something that you can do is you can try and negotiate a penalty if they are more than 48 hours past, or the net 30 days or something like that. So then they
Nice.
end up paying you a little bit more. And a reasonable penalty in the industry is like a 5% kind of thing. It's not a large amount, but it's enough for somebody to be like, okay, I don't want to pay this.
No, I absolutely love that. And I do believe there's also a rule that says that if the insurance company uh, denied your claims when it should not have been denied, that there could be interest accrued on that for every day that they don't pay you. So I love that there can be a 5% interest associated with late payments, especially there are certain payers out there right now that are extremely behind in payments. And so if people don't have that kind of language in their contract, it almost feels like there's no recourse.
There isn't
So
once you sign it, but you can try, and the worst they can do is push back on you. And I know it's difficult because you're negotiating often against a larger entity than yourself. But you got to try.
I love that. I want to shift to that, to standing firm on your position in your negotiations. A lot of times therapists won't push back because it's a standard contract, and you sign it if you want to be in network. But what speaking to the fear, how do you encourage your clients to remain hopeful that what they're asking, A, is reasonable, and it really shouldn't take the insurance company just saying no, but being able to weather it until they get the result that they want? What are some pieces of advice that you give your clients?
So for sure, I'm always like, know what your bottom line is, know what you absolutely positively have to have, and know what your like most outrageous, outlandish possible request is. Those three things. Ask for the outlandish request. Be willing to know that the bottom line is a possibility, but shoot for the thing in the middle. So keep your eye definitely on the thing in the middle, because that's most likely where you're going to land, especially if you're dealing with a larger than life entity, because they uh already are looking at you with a little bit of a boot ant situation. And they do have a lot, right? So they're not gonna, you know that they're not, that you can nudge them past your bottom line. Absolutely, positively. You know that you can. However, they may not be willing to go past your what you need to sustain your practice. And so what you want to do is make sure that you can at least meet that. So that's something that I tell people. Something else that I tell people is that focus on why. Like, why is it that you even are doing this? Is it because, for some people who are in therapy practices or social services or any kind of service industry, myself as an attorney, it's about the people that we work with and the people that we serve and the people that we get to help. And if you can focus on that and not about the fact that you're asking for yourself, because I know a lot of times that can be a hindrance. You think you're asking for yourself, but you're not. You're asking for the help that you do for other people that can help just carry you forward to making that ask. That's that's not legal. That's emotional.
I absolutely love that. It almost feels like it's a form of reframing, remembering your why. I love that. And speaking to that emotional piece, it takes a lot to not only run a practice, but also to pour out your training into other people and to be that support. So when it comes to the legalities, identifying risk in their business and um, avoiding stress, what are some things that you often recommend to your clients?
Um, Hire an attorney. uh, let them do the stressful stuff.
Again,
And
for
then
the
I tell
people in the
the
back who didn't hear you.
I said hire an attorney, let them do the stressful stuff, and then I tell the attorney to get a therapist. Uh, um, when I think it's also important that in order to manage the different demands of being in a business or running a business and the different aspects of life, that there is a little bit of compartmentalization that goes with that, but there is also crossover. So you can't completely shut one out of the other. But you have to be able to know that at certain times, certain things are more of a priority than others. So maybe between the hours of 9 to 5, because that's when you see your clients, your patients, they're more of the priority, and also because your children are at school and you don't have to focus on them as much. But after that time frame, their children are more of the priority because they're at home and you're not seeing your clients as much. And then maybe later, or in my case, I'm a childless millennial by choice and I love it. So, my daytime hours are work related, and then my evening hours are for either working more on developing my work life or my social personal life, and then I have the night to myself or whatever I want to do in that regard. So, there's a balance that goes there, but I have to look at my overall perspective and calendar and stuff and think about that as I run my own practice, right? Because there are ups and downs, there are seasons. It can't just be all play. It can't just be all work either. So, if you are running your own practice, if you are running your own business, if you are making your own product, if you're currently starting your entrepreneurial journey and you are working for somebody else, there is a give and take and a balance that you're just going to have to struggle through for a little while, or not struggle through, joyfully enjoy as you build this process. And on the other side of it is going to be a beautiful like thing that you've created.
I absolutely agree with that. And I love that you went there for many reasons. The first reason is that one of the coaching techniques we'll be using in this course is identifying where you show up in the four quadrants. So to provide more context, one of the exercises that our participants will utilize is called the urgent important matrix. And what it does is it helps the participants identify where they spend most of their time. So whether they're in constant crisis mode, where they should turn it over to an attorney, or they are in quadrant two, which is the goal setting and the preventative and preparation mode, which is the goal. We want people there. Or are they in quadrant three or four, which focuses both on interruptions and distraction? So using that kind of 9 to 5, prioritization, what are they doing in between that time? And that for me is important because a lot of things tend to get missed and overlooked depending on where you fall in quadrant 1, 3, or 4. So that being said, I kind of want to go a little backwards because I see one of the questions on the question list that is really good, and it speaks to what you were talking about earlier in terms of once you sign the contract, it's enforceable from there. Can you talk a little bit about amending contracts and what that looks like for renegotiations and new termination clauses? Because I've also found that there have been clients who they signed up for one thing, but they recognize they need more services. Is it recommended that they should amend the current contract or terminate it altogether? What's recommended?
Right. Totally get it. So everyone hates this answer, but I'm going to say the typical lawyer answer. It depends. But first of all, you want to consider how long you've been in your current contract and the current status of that relationship. Because that's definitely going to make a impact on how you can approach the situation. I would love if emotions had absolutely no play in contract negotiation at all, but that's not the case because we are human. So, you want to consider how long you've been in your contract and the current state of the relationship. You want to examine your term and termination clauses of your contract. That will tell you, again, the term, what the things are that are included in your contract, or the appendix that includes those things that are included in your contract. How many sessions, for example. And then the termination tells you how long your contract is going for. Is it an annual contract that automatically renews? That's an evergreen contract. Or is it a contract that has to be renewed by actual signature or electronic signature every year? Is it a 2-year contract? Like what is the termination date? It is advisable and best to try and renegotiate your contract the closer you, or within a certain time frame. There is no right time frame, but closer to the termination of the contract. Whoever you are, in any case, whether you're the provider or the other party, you don't want to lose. Chances are you don't want to lose that contract. So it's an opportunity to keep the business and on both sides. Keep each other happy, however that works. So it's advisable to try and negotiate as close to the termination date as you can figure out. Also, shop around, see what other kind of competition is out there, so you can just like with job hunting. So you can quote and say things like, well, I know this other option, or you know what's available because in the last year, maybe somebody else has sprung up and has a better deal, better a sign-on bonus or whatever. And that's leverage. Um, let's see what else. Know what you're trying to negotiate. So in the year that you've had this contract, what is it that you're asking for? Can the person or the individual or the organization, entity, business, insurance company that you're asking of, can they even provide this thing? I mean, can Amazon take me to the moon? Maybe someday. But if I ask them that right now, the answer is no. So even trying to get that into a contract with them is stupid. So the
And
idea,
even with the new flying cars out there,
listen, girl, no, 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 no. Not until that thing breaks the sound barrier am I even gonna try. Like, um, so like know what you're trying to negotiate and make sure that the person and an entity can even give that thing. Because if they can't, then there's no win there for anybody. Um, and then proceed with proposing with a proposal to renegotiate, I would say at that point.
I really, really love that answer for several reasons. The first reason is that, seriously, okay. The first reason is that when it comes to fraud and detecting fraud and contract negotiations, like how do we make sure that providers can spot when something is wrong in a contract or just not legally responsible?
Hire a lawyer. Like, I don't know what else to say because as a lawyer myself, like I spot fraud all the time, and sometimes I'm caught off guard when I'm like, oh wow.
Wow.
And so like for me to tell a non-attorney to just willy-nilly try and spot fraud or like hope that they're not being defrauded, I can't. Like, it would be malicious of me to say that.
So, okay, I guess this draws another question. What are some examples of fraud in a contract? Like, I think it's interesting that you said that you have spotted fraud in a contract. So, it goes to tell you, like, people will really go to great lengths to try to get over it. What does that look like?
So people are really notorious lately. This is my favorite thing ever. Lately, people are really notorious for using like AI services for their contracts. So and I'm not against AI at all. Like, I'm like, please write me the social media post right now because I'm tired. Like, amen. But I, but like a legal contract,
Yeah, yeah.
I went to school for many, many years, and I've wanted to be a lawyer since I was 10. I went to school for it, and I have been practicing for a whole decade. My brain has been turned literally inside out. My family cannot stand dealing with me because of the way I talk, and they're like, you're a different person. Even when I was like reviewing some of these questions that people submitted, and I was just answering them, and I was just like, like rapid fire. I was like, who talks like that? So, you know, this is how I live. And so the fact that a computer is supposed to spit that out and interpret the conflicting things about a jurisdiction if somebody has a contract between like somebody in Kansas and somebody in California. I don't think so. There's a reason why they don't let us all practice in the same from every state just because you have one license in one state. That's a little bit different.
Right.
But yeah, so they're using templates and downloaded artificial intelligence things, and people are not cross-checking, fact-checking, making sure that the template that they downloaded is for their proper jurisdiction. So it's fraud in the sense that you are not, if I were to write this contract to you between us, and I have no idea what I'm writing, and I get you into it and we both agree to something, it's potentially enforceable, but neither one of us had the competence to really sign this contract that neither one of us should have written. And I'm defrauding you because I knew that I had no right giving you this contract to sign. It's not fraudulent in the sense that people are putting in false terms, because that's easier to spot for an individual, right? Because you agreed to 8 sessions at $100, not 7 sessions at $125. You know that. So if somebody were to change your terms, you would spot that very easily. If somebody were to misspell your name, you would spot that very easily. But if somebody were to put in an indemnity clause, and in that indemnity clause they were to say that they are completely indemnified against any and all actions that could possibly ever exist that they ever do that has anything to do with this contract between you and them from here to perpetuity, that's not legal, but they could put that in a contract.
Oh, child, you speaking good. You are speaking good. And I think what really sticks out, even just, I'm guilty of it, y'all. I'm not even gonna sit here in front, okay? Maybe I need to hire a new here, y'all. Because I have formed my own agreements on a number of occasions, and now listening to some of the things you shared that may go back and check some things, right? Have an attorney spot. So, you guys have, even myself, a business consultant, is saying, hey, I need to go back and make sure I'm compliant. I'm wondering how many other people um, of our clientele also need to go back. And I say that because, and I had this happen more recently. I had an opportunity to speak at a college, and I knew just from having attorneys in my family that you never just take somebody else's contract or somebody else's handbook, because the wording and the development is catered towards that organization. And while speaking at this school, I heard one of the clinicians who owned a practice actually tell the class that it's okay to take language from another entity and apply it, just change it to fit what you want. And yeah, as you're tilting your head, that's exactly what I did. I'm like, no, that's risky. And when I pushed back, because you're basically saying that after having introduced me as an expert, right? And I'm not even a legal expert at that. So after saying that, I pushed back and said, no, it's not recommended that you take another entity's documents and pass it as your own. You should always have an attorney look over it just to make sure you're protected. And that person pushed back by saying, well, they have attorneys, this entity, they have attorneys, and everybody does it, so it's okay to do it. And I cringed. And rather than go back and forth in that moment, I just kind of left it by the wayside. But there are a lot of people out there who believe that just because these documents come from an association or they come from a reputable source, that there's no obligation to make sure that their practice is protected in that language. So can you speak to that? Can you speak to ways to mitigate risk and not fall into the trap of just using other people's documents?
Yeah, so in law school, we did learn that, like, don't reinvent the wheel, right? So, yes, we use templates, we use formulaic documents. If you were to look at my computer, I don't recreate an operating agreement every single time I write an operating agreement. I have a template, but I edit that template for the client, right? So there are basic things that are included in certain types of agreements, in almost every agreement. But then you tailor it to what you need. So it's going to depend on the matter, but you're going to want to have sections that pertain to the risks that you're trying to mitigate. So like data exposure. If it's data exposure that you're concerned about, you'll want to have a clause about data management. Who has control of the data management on both sides? Who's transferring that data? What to do in case of a leak? How long they have to respond to that leak and like fix it if there is a leak? What data is to be returned or destroyed at the end of the contract, etc. Like that's an example. And some of that information on data, for another, to keep with that example, is statutory depending on your jurisdiction and federal as well. Just because, yay, internet. Um, so some of those things they just are, and you cannot waive your liability, or you can't waive your you can't waive your liability. Your risk is your risk. Once you exchange data, there is risk there, but you can't waive the liability that you have once you are the receiving party, on how you manage that data. Uh, there are certain windows and parameters that you have to stick within. You can do better, but you cannot do worse.
Ooh. So I love that you use the example of data because, as you know, there was a recent cybersecurity attack, and this attack was massive. It affected practices nationwide. And if you are somehow thinking about ways to improve cybersecurity and make sure that you are mitigating your risk as much as possible, what words of wisdom can you provide to our listeners to understand that not being able to afford the system that can help prevent from hackers getting in, how that translates into legal liability when it's a cost issue?
Yeah. So, uh, unfortunately, and there are legal and requirements for for data management, but there is no fund that gives money to people who are small businesses, small practices, individual entrepreneurs, solopreneurs, or anything like that, to be able to necessarily afford some of these systems. And so that is a real gap in the process as far as I'm concerned. Um, I usually advise clients as far as privacy goes, to find the least expensive, most secure suite to that will lock down that information. So I personally, as a solopreneur attorney, I use a lot of the Google suite. And I have a separate cloud drive that I prefer to use, I like have my templates and stuff in my Google Drive, but I have a separate cloud drive that I use for where I store my actual client documents. Um, it is like 3 layers of encryption, blah, 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 blah. It's a lot. Two-step identification, and it's enough to keep within the requirements for privacy and security. And I also, if I'm going to be engaging in certain types of presentations or anything like that, I often will engage in NDA, which will help with any kind of information that I may share in that regard. We can talk more about those. That's like a document that can provide you with legal protection. And so I advise people to also have NDAs whenever they're going to be sharing any kind of information, not with your patients or your clients, because they're sharing information with you, but when you're sharing information outside to other parties or anything like that, to have an NDA.
Oh, I absolutely love that. For a number of reasons. Sorry, my hand was on the mute trigger. Because one of the questions that I posed in um, the list of things that we were going to talk about is what are the components of an NDA? I've seen NDAs where people can't talk about specific things, but they could talk about other things. And what happens if that information slipped? Like, what are the consequences of violating an NDA? Also, I'll throw a caveat question out there because this is also something that has come up amongst clients, which has been around confidentiality or non-compete agreements. Like, how do those also translate when it comes to protecting what's happening internally and making sure that people can move on without, um, I guess, fear of taking what's happening internally and bringing it to competitors?
Mm-hmm. Okay. So generally an NDA will have the parties, the subject matter, the duration of the NDA, so a year, 10 years or something like that. Um, the obligations of whoever's receiving the information and the jurisdiction that this NDA will fall under. So Massachusetts, the Commonwealth of Massachusetts, where I live, for example, would be if I were to send out an NDA, because that is where I live. I was like, I'm gonna say something profound. No, I'm not. So that's generally what's contained in an NDA. With non-competes, I will say in terms of employment or yeah, non-competes are generally related to employment or independent contractor kind of work. Most of those are not really enforceable. They're just scary. And so what's going to happen is, well, many things could happen, but you should consult an attorney if you receive a non-compete, to find out exactly what parts are or not enforceable in your jurisdiction. But most of them are not really, because you cannot really hinder a person's right to work. You can't
I love
stop
that.
them from using their brain and their ability that they have already earned to continue to live. You can stop them from using like physical intellectual property or like materials that they developed within the time that they worked for you over here, but you can't stop them from coming over here and working. So, there's a lot there with non-competes. So you definitely want to consult an attorney if you get one of those. With NDAs, they can be written very, very broadly and be like, so where I send out well, actually, let me talk about the ones I receive. A lot of the ones that I receive deal with the entertainment industry. And so they'll be like, you can talk about that you're working with a feature film, but you cannot mention any of the cast or the directors or the location other
I
than
like that.
the fact that you're in a specific, I live here and they're filming. A lot of films get made in Massachusetts for a tax credit. So, but I couldn't say like, oh yeah, it's the Harvard Bridge for Black Panther too. Like I can't say that. We all know now. So that's fine. But then we didn't know. So I couldn't say anything then. Um so like they can be more broad about like that, or they could be very, very specific. I personally like to draft mine more broadly because the more specific they are, the harder they are to enforce. I have found.
Interesting. Okay. All right. So just switching kind of slightly, it's still around the same concept of enforcement, but it's moving towards um, arbitration versus the court process. So, as an attorney, what do you find has been well, I know you said earlier you're not a litigator, but if you had to make a recommendation, what is a better option for settling disputes? Is it arbitration? Is it the court?
It depends on which side of the table you're on. So, uh, arbitration clauses, one advantage is that it does limit the legal venue, for disputing the claim of breach. So you're using this for a breach of contract. And it does limit the legal venue for that claim, but it also limits the potential outcomes. And so for the party who breached, this is an advantage because if the damages are potentially high, then they could potentially arbitrate a lower penalty and in the conversation, especially if they are the party with the higher bargaining power, because the party with the higher bargaining power, whether they are a bigger conglomerate corporation, have bigger money or whatever, just have bigger personality, may have a better chance in the room. The arbitrator is usually, or should be, definitely on this point, and your arbitration clause makes sure it's negotiated that you both agree to who the arbitrator is, and it should be a neutral third party. But the arbiter is going to do their best to be that neutral third party, but your outcome is limited to what you both come to terms with. In a court venue, you have it's a much more expensive process. You have to pay for an attorney. So you do have the potential of having your attorney's fees paid for by the losing side if that is part of the damage process. So you have a potential of a higher outcome payout for damages or an injunction or something like that with the court, which is an advantage to the party that has been breached. So it depends on what side of the table you're on whether or not you would prefer arbitration or not based on the outcomes that are available.
Wow. I love that. I love that. So you guys heard it. If you're the breaching party, you might just have a winning shot in arbitration, but if you are not, the breaching party. Would you have a higher bargaining chip? You could potentially lose a little, or you could potentially win. I'm gonna pause for a moment while people process. All right. So as we begin to wrap up, and again, I know that it's noisy, and hopefully, when we go to air this, we will have muffled out the background noise, and then it would just be me admitting I was not in a quiet place. But what's one thing that you want participants to really take away from today's conversation? Like, what what is it that you really want them to grasp so that at the end of this, they are thinking about what you're saying and they're picking up the phone call, even if it's just for a consultation or to book your services as a whole? What is that one thing?
In law school, we have a phrase that um something to the effect of, anybody who represents himself has a fool for a client. And so basically negotiating on behalf of yourself is foolish. It's very complicated and difficult. I say like going to the negotiation table on behalf of yourself is a very empowering experience, and you should definitely take that on. But in terms of reading the paperwork and the documentation to get to that point to have that power to negotiate, you definitely want to have a consultation. It does not have to be with me, but it should be with a legal representative who knows what they're talking about and who can interpret what you're looking at.
Ooh, okay. Now this might ruffle some feathers. So for all my friends who are attorneys, I'm sorry in advance. Okay. How can they tell if they have an attorney who knows what they're doing?
Good
How
point.
do how do they vet?
So, similar to how you might vet a therapist, or an accountant, see if they have any. The internet is a great resource. So if they have an online presence at all, there are several websites that rate attorneys, but I don't necessarily approve of those websites because a lot of times you can just pay to get yourself rated. So I would stay away from some of those. Um, like I think Avo is one, Top Lawyer is another, and it's a money grab, and so I wouldn't recommend that. But their own websites will definitely say things like how long they've been in practice, how what their practice is. If you go to the bar association for their particular jurisdiction, you can look up how long they've been in practice and what area of law they practice. You can have a conversation with them and pretty easily determine if they're competent or not. Um, don't be upset if an attorney says something to the effect of, I'm not astutely familiar with what you're talking about, but I will get back to you, because we literally don't know everything, despite the fact everyone thinks we do. But we have the ability to learn things very quickly. And so you may come to me with a question about a particular kind of contract that I do not know the subject matter, but I know contracts. And so I can figure out the two. And then I would say, um, if it's possible to source an attorney through a friend or a relative or a colleague, word of mouth is always really great.
I love that. And y'all, I recommend Naitasia. I know she said you don't necessarily have to go to her, but she comes highly recommended. Thank you so much for your time today. Tell the people where they can find you, how can they book a consultation, how can they learn more about your services?
Yes, thank you so much. So, my website is nvhlaw.com. litigation.com. And my Instagram is active now, and it's my name, Naitasia, Naitasia-ESQ, which is short for Esquire. And yeah, those are the two places where you can find me the most. I'm also on LinkedIn. So if you want to look me up on LinkedIn and verify, say who I am, you can go there too.
I love it. I love it. Well, thank you so much for joining us tonight. And you guys stay tuned for more upcoming lives with Naitasia, Javante. And if you're in the building tomorrow, we have none other than our dear friend, Kelly Saunders, who is from Kelly Sells Cars. She will be going live tomorrow for Do You Have a Winning Sales Strategy? Y'all, you do not want to miss this incredible live. As we dive into what does it take to develop a sales strategy, but most importantly, how do we know it's winning? How do you measure it? So again, thank you so much for coming on, and we look forward to going live with you again. Last but not least, because I know you guys are on the replay and I sort of did this backwards. As I mentioned earlier, Naitasia is one of our instructors in our online coaching program, where this coaching program is focused on recovering your businesses. So if there was any element that stuck out to you tonight, whether it was spotting fraud in your contract, whether it was just making sure that you are contractually compliant and you want to better understand how to protect your practice, your baby, your wealth generating machine, okay? Definitely make sure you sign up for our upcoming coaching program so that we can help you guys recover and be compliant across the board. So look for the show notes, whether you're on YouTube, on social media, or our podcast, because we will put all the information relating to how you can reach out to Naitasia, other resources for finding an attorney, as well as our coaching program. So without further ado, have an amazing night, and we will talk to everyone soon.
Well, friends, that's our time. We hope you enjoyed today's episode. This podcast is sponsored by JLW Medical Management Consulting. We are now accepting applications for the Patient Referral Program and the 90-day Private Practice Bootcamp. If you would like to learn more, please visit us online at www.jlwmedicalmh.com. We look forward to seeing you next time.